The dark, controversial and potentially ominous chapter in Nigeria's political history continues to unfold. The ruling APC party and the country's electoral commission, INEC, have asked the Elections Tribunal to dismiss the petitions challenging the president-elect Bola Tinubu's victory. They've taken particular aim at Peter Obi and his Labour Party, whose petition accuses the APC and INEC of manipulating the results in favour of Mr. Tinubu. They also argue that Mr. Tinubu failed to secure 25% of the lawful votes cast in the Federal Capital Territory of Abuja. But INEC, in turn, is arguing that it conducted the election in strict compliance with the electoral laws. And the Commission, along with the APC, insists that the petition is a waste of judicial time and should be thrown out. They're also challenging the competence of the petitions and have come up with their own counterclaim, suggesting that Mr. Obi was in fact not a genuine member of the Labour Party on the 24th of May 2022, when he was screened by the Labour Party but was still in the main opposition PDP at the time. So it's all getting rather murky, isn't it, as the day of battle and the moment of truth draw near. Well, for more on this, I'm joined now in the studio by the lawyer and former Director of Legal Services and Voter Education at the Electoral Commission, INEC, Osaze Uzi Oluwole, who's had a very long day, by the way. So we're very pleased that you could join us this evening. Thank you for coming in.
Always a pleasure. Thank you for having me.
So you've now seen the lay of the land in the wake of the presidential election, ballot results, which, as you know, is being roundly disputed. It's now in the courts. The battle's preparing to begin there. How would you assess the landscape from the point of view of your privileged perch as the former Director of Legal Services at INEC?
Yes, it's, as you said, has gotten to a critical stage. The votes have been cast, the results have been announced by largely, especially in the presidential case. There's a dispute resolution mechanism outlined in both the Constitution and the Electoral Act, and it says that, look, if you are dissatisfied with the outcome of the elections and you don't think the person who has been declared a winner and returned as elected, you don't think he's qualified, or you think there's been substantial non-compliance with the Electoral Act, or there's a deviation from laid down rules and procedures outlined for the election, then you can challenge the outcome by way of an election petition in a court of law or competent tribunal. For the presidential election, of course, it's the Court of Appeal sitting in its original jurisdiction to hear the presidential election petition. That's how it is. It's been a hectic time for the lawyers in the commission. Prior to the election, you're battling.
It's also a lucrative time, isn't it?
Well, within the commission, I don't know how lucrative it is. You just
okay, well, yeah, but I mean generally, outside the commission.
Yes. I know that in one of the petitions, I think the lawyers involved are volunteers. They are volunteering their time, some of them are volunteering their resources. So not particularly lucrative, rewarding, but not necessarily in financial terms.
Right.
But the others, I think, will be rewarded handsomely, financially speaking. Those with deep pockets will get even deeper, So they've taken some of the best brains in the industry, some of the very best lawyers in the land, experienced old soldiers in terms of election petition matters, senior advocates and other lawyers. It will be an interesting time. The stakes are extremely high. Some believe that we're as close as to annulment as it possibly can. Some think the petitions are quite frivolous. So it's a testing time.
Yeah, it'll be a real challenge for the judges, though, won't it?
Yes, for those involved, there will be a full panel of the Court of Appeal to hear the presidential petition. That's 5 justices of the Court of Appeal. We don't know where they're going to come from. The president of the Court of Appeal has the discretion. She, I guess, will probably preside. It's almost a convention that the president of the Court of Appeal presides, but there's no law about that. I recall that in 1999, the president of the Court of Appeal, who considered the tribunals and considered the presidential tribunal, Court of Appeal to hear the presidential petition, sat the first day, but later on recused himself because his wife was a resident electoral commissioner in one of the disputed states. So he recused himself and replaced himself with somebody else. So 5 justices carried on with the matter.
Yeah, very interesting indeed. And is it a problem that INEC is a defendant in these legal challenges? Does it complicate matters, as some lawyers have suggested? Because, I mean, INEC has no choice but to defend its conduct of the ballot, whereas if it was just a witness, it would be in a less uncomfortable position.
Probably so. There are different schools of thought. In one or two of the Maghreb countries, I'm sorry, I don't know this, I can't recall the specific one, probably Morocco or Tunisia. The election commission comes in as more or less a witness. Come, present your case, and say how you conducted the election. Then the warring parties now deal with each other, fighting out amongst themselves. Some have suggested we should adopt that kind of approach. It turns judicial system upside down, but people say election petitions are use them generis. They are unique. They are different from normal criminal and normal civil procedure. So we should find a unique system, a unique body of laws to deal with its approaches, both in evidence, in terms of the necessary parties. But the law as it stands today, and as it has been for as long as I can recall, is that INEC is a necessary party in all election petitions, even if you're not complaining necessarily about the conduct. For example, if you say somebody is not qualified, he's a drug addict and has been convicted, or he's been convicted of an offense involving dishonesty, technically it doesn't concern INEC, because INEC has no right from the Supreme Court decision in Atiku Abubakar against INEC, Abubakar's case against INEC, that no matter who the party presents, you have no right to disqualify. Only the courts have a right to disqualify. So in that kind of case, people feel, why should INEC defend that kind of it doesn't concern it. It doesn't know anything about this person's qualifications or the disqualifying factors. So it should not be a party. But the law as it stands now, the Electoral Act says INEC must be a party in all of these cases and will be bound by the decision. For example, if it's held that the return was invalidly made for whatever reason, INEC, there's a legal fiction that it has to withdraw the certificate of return given to that person. But in law, once the courts are pronounced, that's it. So yes, some people feel that it's a drain on resources. No matter the number of petitions, INEC has to be a respondent. It has to defend the petition, and it's in the Electoral Act and in the schedule to that Electoral Act that you have to defend. And in the old Act, if you chose not to defend the petition, you had to seek the consent of the leave of the Attorney General of the Federation not to defend it. So by law, you have to defend.
Right, but in your own assessment, I mean, you were Director of Legal Services at INEC, so you know it from the inside, and you're also a lawyer, so you're familiar with the justice scene generally. I mean, what would you suggest?
Well, I think the present legal regime can be modified. I'm not too sure I want to go into a radical transformation of it. I think INEC should defend petitions. It's a big drain on resources. It's a big drain in terms of time and everything else. You are the custodian of all the documents. You are a custodian of the process. You are a custodian of all that transpired in the process. So you have a crucial role to play in determining the justice of what you did.
Yeah, but at the same time, some would argue that because of that defense that INEC has to put up of its conduct, it finds itself aligned with one of the parties who are being challenged in the suit. For example, it goes, people would say, not perhaps in the same terms, but that it gets into bed with the APC, for example, and that would give the APC some kind of advantage, some would see it that way, over the people who are disputing the results of the election.
You're quite right. And often, the last couple of days on social media, I have heard that expression. INEC is very much in bed with the APC. In the States, it might be Labour Party, it might be PDP, it might be whoever won the election. But I was taken aback with that, because we've been doing this for at least 23 years or 24 years. And that law has been the same. Going even further back, it has been the same that INEC has to defend the election.
Well, there are a lot of things we're doing in this country which has been going on for a long time, which really shouldn't be.
It shouldn't be. It shouldn't be. But you conducted the election. You were required to conduct it in line with certain legal framework and certain procedural steps you had to take. So it's only natural that you come and explain to the tribunal the steps you took and on the what basis. What was the process
Yeah,
you
but you
went
can
through
do that
to
as a
return
witness,
this?
not as a defendant.
No, you have to defend your actions. You know,
Right.
it's a defense of your actions. You're not just coming to state that this happened or that happened. If, for example, there were, let's say, missing names on the register, let's just take something out of that. You're not going to say, oh yeah, there are missing names, and then you sit back. You have to explain why they were missing names and what did you do to ameliorate it, and did it affect the outcome of the election. So you have to defend every process, every procedure that you went through. Even some of those things are more or less beyond you. Voter suppression, let's take that for example, is a security issue. But did that affect the outcome? And people say, well, INEC, you should have stopped the election. Whether they can do that legally, I don't know. But they say you should have stopped the election and not made a return.
That's a very good point.
In those areas. So why did you not do so? So it behoves on the commission to come and explain to the justices of the court or the tribunal why it did not do so, and how, if at all, it did not affect the overall outcome of the election. So it's a question of, was there substantial compliance, not necessarily strict compliance, but substantial compliance with the laid down rules, procedures outlined in the Act and in the Constitution.
Very, very interesting. So what in your assessment is at the heart of these cases? Is there a central theme that unites all the petitions that have been filed against the results of the presidential election? Is there something you can point to?
I've read 2 or 3. Unfortunately, I don't think I've read the APM petition. I'll endeavor to lay my hands on all of them so that maybe I can come with a more informed position next time where you invite me here. But yes, I think they're all united, and that's why petitions have been presented. That, look, this man that was returned was not returned with total lawful votes. The majority of lawful votes cast at the election. The only 3 or 4 grounds for presenting petitions, and I think most of the grounds are restricted to about 3. Let me take the Labour Party one. That, look, this man is not qualified because of his conviction. I'm not too sure that is in the PDP one, because of his conviction.
Yeah,
now,
that's in the Labour Party.
In the Labour Party one.
Yeah.
Was there a conviction? What is the import of that conviction, and how does it go on with what the law says, the constitutional provision for disqualifying a person who has been convicted of a felony? But one recurring theme is this failure or lateness in uploading the results. I think
technology, basically, is an issue.
Well, yes, technology. Technology, let me qualify that. Technology is the issue. The use of the beavers is not a problem. The scanning of the beavers, by the way, the beavers is not an electoral act, but it is a coinage of the Commission of the National Electoral. What is an electoral act is you use the smart card reader. The act, even when it came, was already dated because INEC had moved on from the song. But fortunately, we insisted on that phrase of put or any other technological device, and the beavers happens to be another technological device. So the beavers was used. Accreditation, I don't think there's a serious problem with accreditation. The problem with accreditation in some of the petitions was that there was overvoting in certain places. I think that's common to all the petitions too. There was overvoting, and the definition of overvoting has been changed. Prior to now, overvoting meant that there were more votes than the total number of registered voters in that particular polling unit. But now it is that there were more votes than the total number of accredited voters, which makes more sense. So you don't say, because it's how many people who turned up to vote, and we're giving ballot papers. If only 100 people turned up to vote in a particular polling unit, you should not have 101 votes cast for all the parties put together. So that's a good thing, and that's where the beavers has been a wonderful thing, and that is one of the reasons they look, in certain places they have found out that there was overvoting because many people voted without passing through the beavers. The law says you must pass through that either smart card reader or that technological device which INEC has put, and the beavers. So that is there. Then the uploading of results. But the problem I see with the uploading of results is that you cannot say that it's a necessary prerequisite, it's a precondition. And the law says that, look, before you start collation, the collation officer or return officer must ensure that 2 things. 1, he sees the beavers. He compares the total number of accredited voters in the beavers machine and that which is recorded in the EC8 series. That's the EC8A, that is the result sheet.
The form,
so ensure that they correspond, that they're correct. And then the second thing he does is, look, where is the result transmitted from the polling unit electronically? He will look at that, which is contained in the beavers, but it's uploaded to the collation system and ultimately to the IREV. He should look at that. Where the collation system is not available, he looks at the IREV. They're through a dual system. He now looks at that and say, look, okay, great. What are the scores of the parties? Party X got 200, Party Y had 150. He has to ensure that is exactly the same as it is recorded in the...
And did INEC fail to do that
in your assessment? It's not an assessment, it's a factual thing. It will appear so. And because, well, I know of the IREV, I don't know about the collation system, because we are not privy to the collation system. So only the administrators and those few people in INEC who are probably returning officer, collation officers who are privy to the collation. But the IREV is supposed to mirror that collation system. Yeah. So we know that most of the presidential results were not uploaded, even as at the time that the return was being made. So in my assessment, there was a breach. What effect that has in the election, I don't know. Yes. That is now for the tribunals, for the Court of Appeal to determine. So, and they're arguing that yes, that might be so, but it's not sufficient to vitiate. It's not sufficient to annul the election. And the petitioner saying no, it is sufficient to annul the election. You know, because the issue in the next, look, okay, fair enough. Even if we did not do this, you had copies of those results. And if you tally them up, it's not according to INEC, it's not significantly different from the result we eventually announced. And if you recall, during the collation, the chief returning officer of the Constitutional Electoral Commissioner, the chairman, made allusions to that. Do you have a contrary result? If you do, kindly produce it. So I think that has been carried on to the reply and the defense in the petitions to the Court of Appeal, saying, look, yes, I might have given you, I gave you a result, I gave your agents a result. Fair enough, I may not have uploaded as at that time because we had technical glitches. So, the result I'm now announcing, and the result I'm now uploading or subsequently, or the result I'm now producing here, it's not different from that which I gave to you. In some cases, we have seen that there are some differences. But how widespread that was, I don't know. It has to be demonstrated in the courts for them to see.
That's a very good analysis. And do you normally have this number of legal challenges against the result of a presidential election in Nigeria? I mean, at the last count, there were about 5 or so.
Yes, 5. I'm aware of 5. I don't know that anymore. The time for filing has closed, so I just presume there are only 5. Now, let us not compare cheese with apples. There are a lot fewer political parties now, 18. I think the last time it was 83 or 84 that contested the election. So if there are more, then it's not to be unexpected.
Right.
Results have been challenged in this country. Results have been very controversial. In 1983, I think there were 5 political parties. So I don't think all 5 of them, I remember correctly, PRP did not go to court. Awolowo did in 1979, for example. With the more political parties there are, the chances are there'll be more cases of petitions. In 2007, I was director legal. I think we had over 600 odd petitions. I can't recall now how many were challenging the presidential election, but quite a few. I know that over the years, MD Yusuf has challenged, Buhari has challenged it so many times, Hope Democratic Party, Uru has challenged so many times, Fresh with Chris Okoti has challenged severally. So there are lots of people, some names, nostalgia is taking over.
I mean, when you're reminiscing about that past, I mean, I wonder, when you were the director of legal services at INEC, I mean, how much of your time would usually be taken up by these legal challenges in a post-election dispute resolution period? Would you be tearing your hair out about now, for example?
About 25 hours in every 24-hour period, probably. Yes, because not just the post-election, even the pre-election. And I think this cycle is almost unprecedented. There's so many cases in the pre-election cases, in the intra-party cases, you know, and so they are still being running through the mill. They're still being in the process, and they're now merging into the post-election period because now you now have the petitions to contend with. Not just, you see, in doing this, you have to instruct counsel. You have to look for the funds. In my time, for some quirky reason, there was no money to defend the petitions. And I had lots of...
Well, they seem to have a lot of money this time.
It will appear so. A lot of people came to me and said, look, it's 2 days and I've not seen anything. I said, well, sorry, I only have, 30 staff or 40 staff at that time, and I don't have any money to engage external solicitors. So they came and said, no, I can give you some money. I said, no. That impugns on my independence and my integrity. You know, I cannot take a counsel from you. So already they had to go and they went to session and passed the supplementary budgets, and I think released about 1 billion naira or thereabouts for defense. Because not only do you have to retain counsel, there are issues of logistics. There are issues of moving materials from all over the country, sometimes to a central point. You have to duplicate registers, for example. The same register was used for all the elections, and it might be required in different tribunals. So there are lots of challenges and expenses to be borne by, and you're running your generator almost 24/7. So you have to fuel the thing and everything else. So there's lots of expenses
I can imagine.
involved.
Well, very interesting, and thank you for sharing that with us. And thank you very much for coming in. Osaze Uzi Oluole is a lawyer and former Director of Legal Services and Voter Education at the Electoral Commission, INEC. Thank you so much.